manager, if he wishes, could ignore those extensive provisions in the standing orders of this Honorable House, which specifically detail how we could cut or amend the budget. And they try to say it is not law. But we have substantive arguments to show that it is an instrument of law. And once it's an instrument of law, it is law. And so this matter is before the court, Mr. Speaker. And perhaps we should continue to operate in an independent manner and in a manner in which we feel we are justified in doing until the Caribbean Court of Justice determines this matter. And that's my respectful submission.
I will raise one last time, with your kind permission, sir, because my senior political advisor advised me, and for good reason, that I just read for the purpose of the record, read into the record, Article 280. My learned friend has dealt with the Appropriation Act. We have long past that stage. 218.3 deals specifically with situations thereafter. And it says, if in respect of any financial year it is found, A, that the amount appropriated by the Appropriation Act, to which my friend makes reference, for any purpose is insufficient, or that a need has arisen for expenditure for a purpose for which no amount has been appropriated by that act, or that any monies have been expended for any purpose in excess of the amount appropriated for that purpose by the Appropriation Act, or for a purpose to which no amount has been appropriated by that act, a supplementary estimate, and that is what we are doing here, as the case may be, or a statement of excesses, and that's what we are doing here actually, showing the sums required or the sums spent shall be laid before the National Assembly by the minister responsible for finance or any other minister designated by the President. And that is what the Constitution. That is what the Constitution.
Just quickly, Mr. Speaker. One line. I'm respectfully submitting that what is read out as 218, Article 218, Paragraph 3, does not apply where the Parliament or the National Assembly cuts their them. And the item is cut. You can't come and say that it was no provision for the item. These items were cut. These items were cut. And they don't fall within the purview of Article 218 of Paragraph 3.
Mr. Ramzan,
I just want to ask a specific question of the Minister. The Minister of Finance, this $270 million that you want approval of now, was it an amount that was taken to pay Gina and NCN staffers from that $4.4 billion on the revised wages and salaries?
any minister here to answer, not
Mr. Chairman, the coding structure.
I want to check it on the virus.
The coding structure is a matter of public record. This is an allocation under Agency 01, Office of the President.
I just am asking the question. I'm sorry.
What's it Mr. Chairman, when the honourable member is prepared to allow the chance
Mr. Bernard.
Thank you very much, Mr. Speaker. I'd like to draw to the House's attention the fact that Article 218, to which reference is made, never intended, it was never intended, and it could not be intended, to be a carte blanche for the Minister of Finance to spend whatever he likes. That is the point. Whether or not there's a shortfall does not authorize the minister to simply spend. The spending of monies out of the consolidated fund is conditional. If you listen to the man instead of talking nonsense. If the article is taken in conjunction with the legislation that this government itself passed, the Constitution is not to be read in its own right. That's nonsense. It just shows you don't understand it. Mr. Speaker, the Constitution sets the broad parameters, and within that, the legislation sets out the specifics in which it is to be applied or interpreted. Otherwise, there's absolutely no point in having the legislation. They go hand in hand, they are complementary. So when the minister deems the expenditure to be insufficient to meet a purpose, then he may use funds from the consolidated fund on the understanding that he is going to be able to defend it in the House and clear it. But the context in which he defends it is very clear. The legislation, even if you want, as the case of the Chief Justice, even if you want to assume that only the criteria established in the Constitution is relevant, let me say to you, Mr. Speaker, and to this House, that the criterion is urgent. The criterion is urgent. And money being spent over 9 months cannot be urgent. Mr. Speaker, let me show you the legislation. Article 41 reads as follows. Section 41(3). 41(3) is carefully worded. It reads as follows. The minister, when satisfied that an urgent, unavoidable, and unforeseen need for expenditure has arisen, if you want to dispute the 3 terms, I don't mind. You can't dispute urgent because it appears in the Constitution as well. When you read the rest of it, the minister is required to satisfy himself, okay? To satisfy himself about certain things which he will have to persuade the House of. And as regards those things, let me just say to you, Mr. Speaker, that he is supposed, for example, to meet 3 criteria here, for which no money, the first is for which no money has been appropriated, or for which the appropriate sum is insufficient. It wasn't a question of the sum being insufficient. The House deliberately reduced it. The House deliberately reduced it in the knowledge that it was not available. Not available. That was the intention. Secondly, he needs to show, Mr. Speaker, that monies could not be reallocated from other areas. That has been shown. Thirdly, and most importantly, it says here in C, expenditure, and I'm paraphrasing, which cannot be deferred without injury to the public interest. Now, Mr. Speaker, I will also show you that the continuous abuse of the minister and the PDP of their own legislation. If you have a look at section 6, section 6 requires, sorry, not section 6. If you look at section 24(4) speaks to the need to present with these requests certain information. It makes reference, for example, to a supplementary document. Which supplementary document is supposed to explain the impact that the variations if approved will have on the financial plan outlined in the annual budget. In other words, there is not, I'm saying to the House, Mr. Speaker, at no point does the Constitution or the legislation enable the minister to just at his own discretion, spend money on the understanding that he doesn't have to come to this house. And the fact is that the minister, Attorney General, the Chief Justice himself, Mr. Speaker, in making reference to the article on which the government hangs its hat, is very clear. It says, the court cannot substitute itself for the minister for the purposes of Article 218, 218.3, and Articles 221 and Section 41.3 of the Fiscal Management and Accountability Act. So, the Chief Justice himself recognizes the import of the Fiscal Management and Accountability Act in conjunction with the Constitution. And he said, in implementing that Article 218.3 amongst the others, the court cannot substitute itself for the House because only this House can approve that. I'm saying to the extent that the House deliberately took a decision not to fund these things, it is an insult for the minister to bring it back to us as though it is a new, sudden, unexpected, unanticipated expenditure. I urge you.
Mr. Chairman, permit me, sir, it's not my intention to have this matter protracted unnecessarily. The honourable member quoted from the Chief Justice's ruling, and perhaps conveniently chose to omit a very significant statement made in that ruling, page 31. Mr. Speaker, the Honourable Chief Justice said very clearly, and I quote, "It is not for this court to substitute itself for the Minister of Finance. It is he, that is to say the Minister of Finance, who was made the prerequisite finding under Article 2183 of the Constitution, and it is he who must be satisfied under Article 221 and Section 41.3 of the Fiscal Management and Accountability Act, and not the court." But Mr. Speaker, permit me also to draw attention to a matter, I need to respond to a matter raised by the honourable member, Mr. Greenidge. In his reference to Section 41 of the Fiscal Management and Accountability Act, Section 41 addresses the contingencies fund and spells out the circumstances under which the contingencies fund may be utilized. I would like to think, sir, that the honourable member would be aware that the enactment of Section 41 in the Fiscal Management and Accountability Act is derived from a constitutional provision separate and apart from 280. There is another constitutional article, Article 220, that says Parliament may make provision for the establishment of a contingencies fund, etc., etc., etc. Deriving from that constitutional authority in 220, Parliament proceeded in 2003 to enact Section 41 as part of the Fiscal Management and Accountability Act to establish the criteria to which the honourable members are alluding is criteria reading from the very act that he is reading in the same section that he is reading, is criteria attached to the contingencies fund. Article 218 speaks to the consolidated fund and speaks to such circumstances where sums appropriated, however we might have arrived at the Appropriation Act, whether the Appropriation Act was passed amended or unamended, cut or uncut, however we may have arrived at the destination of the Appropriation Act, once enacted, should an insufficiency arise, Article 218 becomes relevant and
The whole business of public expenditure is one of the hallowed and indelible features of the Westminster system. Indelible in that it says that the government and the government alone must have the right to spend, and the National Assembly, on the other hand, must approve with or without amendment or disapprove. Government under the Westminster system must have the right to execute its policies with the least bit of hindrance. Last year, we had a situation where 2 financial papers were rejected, and I did give a ruling which I've asked request to bring up. In which I said that the government must have the right to come as often as it wishes, whenever it wishes. That is its constitutional role and mandate, and it has the authority to come if it wishes 100 times to this House. But the House has no duty to prevent the government from coming. What the House has to do when it is petitioned is to say, yes, we approve with or without amendments, or no. But the government must never, and this House has no authority to prevent the government from seeking to have appropriations whenever it needs. Now, we have had a recitation of Articles 218, 220, Sections 19 and 41 of the Fiscal Management and Accountability Act. And also, I should not forget the Chief Justice's ruling. And we can go on ad nauseum with different interpretations of what these say or they don't say. I believe, as I said before, that government always, under our unique Westminster system, must always have the right to seek financing. Article 220 does give does create a contingencies fund and does give the minister the right to draw down, if in his opinion, because Section 41 says of the Fiscal Management and Accountability Act, the minister shall have the sole authority for the release of monies if the minister is satisfied that the request is unavoidable and unforeseen for expenditure which has arisen, and for which no money were appropriated, reallocated, or which cannot be deferred without injury to the public interest. And that is in the sole discretion of the Minister of Finance. What I'm saying, 1 second. When the Minister makes the petition to the House, it is for the House to say we do not agree with you. But it is not for the House to shut out the Minister. The House has no authority to shut out the Minister. Because it is for the Minister to come and say that it is in his opinion, I have done this and I did it for these reasons. When the request is made to the House, it is for the House to say we don't agree with you, which is what I believe you say, Mr. Greenwich, which is your right, or we agree with you. But we cannot say to the Minister that you cannot come. But it is ultimately the responsibility of the House to say the reasons you have advanced, Mr. Minister, we do not agree with, we do not find favor with, or we agree or find favor with. So, thank you, Mr. President. The ruling was number 5 of 2012, in which I said that I'm just restating what I said before, that it is a hallowed and indelible feature of our Westminster system that government must have the right to come. And that is why it evolved out of what is known as a royal recommendation, that whenever a money bill is brought, you hear the minister saying that the cabinet has given its approval and so forth. So now that we are seized of the matter, it is for the House to say by a majority whether or not it approves of what the minister has done with spending, or it disapproves. If it approves with or without amendment, or if it disapproves, it rejects it. We may be offended by the steps taken or not offended, but at the end of the day, both the Constitution and the Fiscal Management and Accountability Act say that the minister is the sole authority, but he or she, but I don't want to say that we shall not ever have a female minister making a presentation, he or she must submit that action for approval by this House, and that is where we are at this point. Or grant of their approval. That is what it is.
So I would just wish to make, and I do not like to differ from you, Your Honor, Mr. Speaker, but assuming this House were now not to approve, that money was already spent. So there would not have been legislative authorization for that $270 million. And that is the conundrum under this head we are going to have. But no, we cannot, because it becomes illegal. He, having satisfied himself, Mr. Speaker,
he having satisfied himself, ultimately what the Constitution contemplated was a kind of come here.
We are considered today financial labor number one.
That's right.
That is what we are going to consider a financial paper number one.
No, but let's have them up and
Yes, but this committee of supply has no authority to go into any other matter other than considering a financial paper that is before it.
No, but assuming, but very well, the assumption they're making is that assuming
But
this
then
thing,
the House may wish to consider other action, but in this committee,
But very well,
there are only two functions that we can perform. Approve with or without amendment or disapprove, but we can't go beyond what the standing order provides.
May I just add as a right, in view of your decision, let me say to you that I am aware that the Constitution does limit the number of times the minister can come back to the House, although you said it should be unlimited. It does limit it. It also requires that the minister come back at the next sitting in relation to these expenditures. That is not the case for money spent in April or May or whatever. Let me just say that I'm not arguing with you, but I'm saying that in the light of what has happened now, we will move to take action against the minister for what we regard as an illegal right.
My duty is to put the motion that is before the House, before the committee, or its approval or
spending money and it's
Mr. Chair, go ahead,
President or not, I understand the various issues being canvassed that I had sent for my seat. Article 283 does not apply because 218.3 speaks to a purpose. Money spent or required to be spent must be spent for a purpose not contemplated previously or for a purpose that was, I'm interpreting what the Constitution says. I know you have so many constitutional experts over there. This money is for an entity. There is no purpose articulated in the explanation, the rubric. If you look at it, it's simply usual bald provision of subsidy to the GILA and NCN. But I want to, if you permit me, Mr. Chairman, to say that the purpose could only be the propaganda use of GILA and NCN of state for the use and purpose of the ruling party, the minority party. And that's what the major contention of this House. I'm trying to find a way out. Merely cutting, approving or disapproving some sort or spend, it is not going to solve and address the issue. The issue is if the state media were democratized and opposition, political parties and civil society had access to them, then the issue of cutting allocation or subvention to FCN and GINA would not have arisen. So the next explanation I would hope to see in the ledger, yes, of course, the scissors will be relevant so long as you refuse to democratize these media. It will always be applicable. The glorious scissors. So that is how it is not ultimately the Constitution or the financial management provision of the Act that will address this issue. This issue has to be addressed politically. And I thank you, Your Honor, for allowing me to say this because I've heard the Lord Attorney General and the Finance Minister, Honorable Finance Minister, referring to the Constitution. By the Constitution, under Moses Nagamutu as Minister of Information, the state media was democratized. It had broad-based laws and management. investigated and people can't be punished for it. It is the aberration that is causing us problem. So it's like, we will not approve this allegation until the political will exists to democratize this media.
Honourable members, sorry.
Don't put the camera in.
Thank you very much, Mr. Chairman. I think the matter that is under consideration is a statement of excess. And we're not dealing here with contingency fund. And for the record, sir, I'd like to state that this money was spent for the purpose of the state communicating information to the citizens of this country. So, conclusion to be made in very different ways. But Gina is not the propaganda arm of the ruling party. I think the ruling party has its own outlets, its newspapers, a lot of ways of getting its information. Gina is a state apparatus. And if we have problems, then the functioning of Gina is a different matter. The functioning of Gina. Secondly, sir, the issue of NCN. NCN serves every Guyanese. It is the only entity. It is the only entity that pays for the sporting rights to broadcast some of the sporting activities that Guyanese are so dependent on. It's the only station that does it. And while there could be a lot of political speeches made about this, what we are presenting to this House, in fact, is that on the contributions and subsidies to local organizations, the Office of the President have made contributions to these two entities in statement of excess because what was allocated was insufficient to meet the needs and objectives of these entities to serve the citizens of Guyana. Thank you very much.
In committee of supply, our only function is to approve or disapprove. And so, I wish to put the question that if the committee of supply approve of the proposals held in financial paper number 1 of 2013, statement of excess, current and capital totaling I'm putting the entire $3,384,500. Sorry, $217,194,998. All those in favor, say aye. Aye. Those against? No. No seem to have it. Division is called. Taken by the clerk, I'm advised that 32 members voted in favor of the motion for the approval and 32 members voted against. The motion is not carried. Honourable members, it is 5 minutes past 4. Financial paper number 1 has 3 other items for us to consider.